Have you ever felt a verdict was decided before the trial even began? By 1978, Ted Bundy had escaped custody twice. His name was already known far beyond any one courtroom. But here is the point. Notoriety is not evidence. For the people killed, attacked, and left waiting for answers, a famous name could not do the work of a legal system. Someone still had to identify the charges, test the evidence, hear the objections, and let a higher court examine the result. That is the story here. Not how to turn a killer into a legend. The opposite. It is a story about the limits of legend. When the public thinks it already knows the ending, what does a courtroom still have to prove? Start with the documented road to Florida. By 1974, the FBI says investigators in Washington were dealing with the disappearances of young women. In August 1975, police arrested Bundy in Utah. The next February, he was convicted there of kidnapping and assaulting a teenager who escaped. Then came the escapes. In June 1977, while facing further proceedings in Aspen, Colorado, Bundy escaped custody. He was found days later. On New Year's Eve, he escaped again. The FBI joined a nationwide search, circulated identification material, and placed him on its 10 most wanted fugitives list on February 10, 1978. Think about the contrast. A nationwide manhunt can feel like a movie, but the moment that ended was, on its face, almost ordinary. It was around 1:30 in the morning in Pensacola. A patrol officer noticed a stolen Volkswagen and made a stop. The driver resisted. He was taken into custody and identified as Bundy. No invented chase scene is needed, no dramatic speech. The documented stop was enough. The search was over. And the harder part was just beginning, proving the Florida cases in court. Florida prosecutors brought separate cases. One concerned the attack at the Chi Omega sorority house near Florida State University in the early hours of January 15, 1978. A July indictment charged 2 counts of first-degree murder, 3 counts of attempted first-degree murder, and 2 burglaries. The Florida Supreme Court later described the result. Convictions on those counts, with death sentences for the 2 murder convictions. The other case concerned Kimberly Leach, a 12-year-old girl reported missing from her Lake City Junior High School on February 9, 1978. In July, Bundy was indicted for murder and kidnapping. It is important to pause there. Her name should not become just another detail in a story built around someone else's notoriety. A legal case about a child is first a case about a child, a person whose life mattered and whose absence reshaped other lives. Now, this is where many retellings become flat. They jump from arrest to verdict as if the rest were automatic. It was not. Public attention was enormous. Courts still had to deal with jury selection, publicity, evidence, and the rules for a capital case. And that matters more than it may sound. A fair trial is not a reward for someone accused of terrible acts. It is how a legal system makes a verdict trustworthy. If the rules only matter when the defendant is sympathetic, then they do not really protect anyone. Here is the legal part, in plain English. An appeal is not a new trial. It is not lawyers asking the public to vote again. It is a review of whether a legal or procedural error requires a conviction or sentence to be reversed. You can think of it as the system checking its own work before asking everyone else to accept the outcome. In the Chi Omega appeal, the Florida Supreme Court reviewed objections that included pretrial publicity and jury selection questions. In 1984, it affirmed the convictions and death sentences. In the Kimberly Leach case, the court reviewed the separate conviction and sentence. In 1985, it affirmed those as well. That does not prove every claim ever repeated about Bundy. It does establish something more precise. The Florida convictions and sentences in these cases survived the appellate review described in the court opinions. That distinction may sound careful. It is careful. In cases retold for decades, careful language is a form of respect. The final stage of the legal record was public too. In January 1989, Florida's governor signed a death warrant scheduling execution for January 24. Bundy was executed in Florida that day. It can be tempting to make that the whole ending, to treat it as the last scene and close the file. But the people at the center of these cases were not props in a crime story. They were people whose deaths and injuries required investigation, prosecution, and a record strong enough to withstand review. Survivors and families had to live with the consequences long after the cameras and headlines moved on. So what stays with us now? In a high-profile case, publicity can create the feeling that facts are already settled. It can make patience look like weakness, but courts cannot work from that feeling. They have to test a specific charge with admissible evidence and procedure, then allow challenges to be examined. That discipline can feel slow. It can feel unsatisfying when anger is real and the harm is irreversible. But without it, a verdict risks becoming only a story the loudest audience agreed to tell. The Ted Bundy cases are remembered for escape, notoriety, and spectacle. The legal record asks us to remember something harder. Justice is not made stronger by shortcuts. It is made stronger when evidence is tested, rulings are explained, and the people harmed matter more than the fame of the person who harmed them.